Welcome to Immigration Review, your weekly source for immigration case law updates and insights. I'm your host, Kevin A. Gregg, back again to review the week's precedential immigration cases, rummaging through the decisions so you don't have to. This podcast is sponsored by Kurzban, Tetzelli & Pratt, also known as KKTP, a law firm where I'm also a partner. Whether you are facing an immigration obstacle, a serious injury, or a legal issue in your business, KKTP will aggressively protect your best interests. This podcast is also sponsored by DocketWise, an all-in-one immigration forms and case management solution trusted by thousands of immigration lawyers across the U.S. I really like DocketWise. It makes immigration applications easy by allowing the clients to provide information through simple online questionnaires that are shareable by text or email and available in multiple languages. Not only that, DocketWise provides a comprehensive group of case management features, including invoicing and calendaring, secure messaging, task management, and a lot more. You can learn all about DocketWise and receive a 10% discount on your subscription by heading to docketwise.com/immigration-review, so they know we sent you. And as always, this show does not constitute legal advice and has no bias other than to keep you up to date and to enable you, my dear colleagues, to excel in court. So, without further ado, let's start the review. Welcome to another monster week of Immigration Review. I wanted to promo another lovely workshop coordinated by Helen Tarokic and her team of T-Visa experts. Coming up soon is Improving Your T-Visa Screening Methods with Jenny Amo. Miss Amo is a retired FBI agent who worked to combat trafficking for years. She knows a thing or two. Helen and Jenny have been a huge help to me as I add T-Visas to my arsenal, so I suggest you check it out. Link to the training in the show notes. Also, at the 11th hour this week, the BIA published matter of JGR, but I didn't receive the usual BIA notification email, so we must kick the decision to the top of next week. It's a Convention Against Torture case, and it looks like the non-citizen succeeded. And at the 12th hour this week, the 6th Circuit published a criminal decision that almost decided whether Michigan's definition of cocaine is overbroad itself because it includes more isomers than does the federal definition of cocaine, the isomer argument. But ultimately, the 6th Circuit held the issue in abeyance pending a decision by the Supreme Court next term in Jackson v. United States. I wasn't aware of Jackson, and it seems like there are more issues in that case than just this isomer-type argument. But oh boy, we might have a big crimmigration affecting decision from the Supreme Court next term. Can't wait. And with that, on to the 8. To begin, we have Fonseca-Fonseca v. Garland, published by the 9th Circuit on August 8, 2023. This decision is about motions to reopen. And it's kind of a big deal. It's about burdens of proof. That boring topic with very real-world consequences. The Josh Altman favorite matter of Coelho versus matter of log dispute. Matter of log 1. Rejoice, Josh. Stepping back. Mr. Fonseca-Fonseca entered the United States way back in 1994, seemingly without authorization. 20 years later, he received a notice to appear, placing him in removal proceedings. That NTA was deficient, as it lacked the date and place of his first hearing. Mr. Fonseca-Fonseca initially applied for non-LPR cancellation of removal under INA Section 248B in removal proceedings, but withdrew that application after he realized that he couldn't establish the 10 years continuous physical presence required for that form of relief. Unsure why not with an initial entry in 1994, but I don't know. Maybe he was going back and forth to Mexico, undiscussed. Mr. Fonseca-Fonseca applied for asylum and related relief, but was denied by the immigration judge. But it seems that while the matter was on appeal to the BIA, or just before the appeal, the Supreme Court issued Pereira, explaining that a deficient notice to appear does not, as it turns out, stop the accrual of continuous physical presence for non-LPR cancellation of removal. Later precedent would explain that a notice of hearing doesn't either, that's Ms. Chavez, nor does even a removal order. The BIA, of course, rejected all of those arguments way back when, but they were wrong. Mr. Fonseca-Fonseca eventually moved to reopen his now final order of removal, presenting new evidence that his U.S. citizen children would suffer extreme and exceptionally unusual hardship without him, arguing that if given the chance, he could establish his eligibility for non-LPR cancellation. By this point, it seems like the BIA had to concede that yes, Mr. Fonseca-Fonseca had the 10 years continuous physical presence because of all this deficient NTA case law. But the BIA held that nevertheless, Mr. Fonseca-Fonseca hadn't established his prima facie eligibility for cancellation, so the BIA was not going to send back the matter to an IJ to allow him to apply for the relief. And that is what we have before the Ninth Circuit, the denial of that motion. And that's true. To succeed on a motion to reopen to present new evidence to apply for relief, a non-citizen must establish a few things, including prima facie eligibility for that relief. But what does that mean, prima facie eligibility? Well, quote, "Today we clarify that prima facie eligibility for relief requires only a threshold showing of eligibility, a reasonable likelihood that the petitioner would prevail on the merits if the motion to reopen were granted. As the BIA previously explained, a non-citizen demonstrates prima facie eligibility for relief where the evidence reveals a reasonable likelihood that the statutory requirements for relief have been satisfied." End quote. The non-citizen need not establish that the new evidence would, quote, "likely change the result of his case," end quote, as a matter of Coelho would like. That is a, quote, "substantively higher bar," end quote. And it's a big deal that the Ninth Circuit is materially and conclusively lowering the bar for motions to reopen in the Ninth Circuit. But what about matter of Coelho? Perhaps the most often cited BIA decision of all time. Well, explained the Ninth, all the language about what a prima facie showing requires in Coelho was dicta. In that case, the BIA denied the motion really because it determined that even if eligible, the respondent there didn't warrant the relief as a matter of discretion, explained the Ninth Circuit. But matter of log and then matter of SV, published after Coelho, are directly on point. And they apply that lower reasonable likelihood prima facie showing standard. And this makes sense to the Ninth Circuit because a prima facie showing is, after all, merely a threshold showing. It's not the whole case. Quote, "A standard that requires a prima facie showing that new evidence would likely change the agency's eligibility determination is counterintuitive. It would essentially bypass the prima facie requirement and require the petitioner to proffer evidence that proves her claim for relief at the threshold," end quote. Doesn't make sense. Indeed. To the extent the Ninth Circuit has cited an incorrect standard in reviewing motions to reopen in the past, that was error, and it can't be relied on anymore. Stop relying on matter of Coelho, IJ and BIA law clerks operating in the Ninth. Case remanded. Congratulations Andrew J.S. Newcomb and Elias Mendoza for petitioner. And it's got me thinking. I need to go back and review the case, but I can only imagine that all of this makes the prima facie discussion from matter of Chen, episode 142, bad law or on shaky ground in the Ninth Circuit. Because in Chen, the BIA definitely applied a very high standard for its prima facie showing requirement for it to approve a motion to reopen so a non-citizen can apply for non-LPR cancellation of removal where the NTA was deficient. Even if the BIA didn't say it, it seemed to have been applying a Coelho or even higher standard in matter of Chen. Seems, quote, "substantively higher," end quote, than a reasonable likelihood standard to me. Matter of log is the law in the Ninth Circuit. And that is Fonseca-Fonseca v. Garland. Next up is Garcia-Gonzalez v. Garland, published by the Fifth Circuit on August 7th, 2023. This case was almost about family-based particular social groups, but it's really about ineffective assistance of counsel, motions to reopen. Ms. Garcia-Gonzalez and her minor son are asylum seekers from Honduras. She and her son fled Honduras and entered the United States without authorization in 2016 because gangs were trying to recruit her son. The gang had already kidnapped Ms. Garcia-Gonzalez's nephew in a similar attempt and threatened to murder her son, Kevin, if he didn't join, and to murder Ms. Garcia-Gonzalez. In removal proceedings, Ms. Garcia-Gonzalez claimed asylum on account of her membership in a particular social group made up of the nuclear family of her son. Her son was a derivative on her application. Why wasn't the son the primary applicant when he was the one who was getting recruited? 2 reasons to me. Harder to claim that he's a member of a particular social group made up of a family when he is the direct threatee. But more importantly, Ms. Garcia-Gonzalez, as his mother, can't get asylum just because her son does. But as her child, he can get asylum if she wins. But Ms. Garcia-Gonzalez, represented by an attorney, missed her deadline to submit her fingerprints. The immigration judge had given her 6 months to do it at a master calendar hearing. Now, Ms. Garcia-Gonzalez can't just go get her fingerprints taken somewhere. She needs to submit her asylum application to USCIS, which then needs to set a fingerprint appointment. All of this even though the IJ has jurisdiction over the asylum application, and that the asylum application was already filed with the immigration judge. And if USCIS doesn't do it or messes up, it is very, very hard to get a hold of them. You're essentially yelling representative into their 1-800 number from hell. It's a bit of an unnecessary, cumbersome process that begs for unintended and consequential errors. And that's what happened here. The attorney, it seems, never sent the application to USCIS to get him to set the fingerprint appointment. And the attorney then fell on her sword before the immigration judge and admitted it and conceded it and begged forgiveness. That is, failing to submit the asylum application to USCIS just so she could get a fingerprint appointment for her client. The immigration judge did not forgive and denied the asylum application as abandoned. Again, even though the application had been filed with the immigration court. The IJ suggested that Ms. Garcia-Gonzalez file an ineffective assistance of counsel claim against her attorney, which in the Fifth Circuit, as nearly everywhere, would require a formal bar complaint against prior counsel for making this calendaring mistake and then taking responsibility for it. New counsel came in for the appeal to the BIA, but refused to file an ineffective assistance of counsel claim against prior counsel. That second attorney gave Ms. Garcia-Gonzalez a choice: get another attorney to file the ineffective assistance of counsel claim, or choose not to, and hire me, second attorney, to file this appeal. Ms. Garcia-Gonzalez took the appellate route with the second attorney. The BIA denied the appeal. Pretty difficult to win on such an appeal. The asylum application was denied, after all, as abandoned, and that's a hard thing to challenge on appeal. The BIA noted counsel's failure to file a bar complaint against prior counsel in its denial of the appeal. Again, we're talking about a fingerprint appointment. The BIA denied the appeal and refused to remand for second counsel's failure to comply with the bar complaint requirement of matter of Lozada. I have included a link to Rekha Sharma Crawford's petition for clarification or vacation of matter of Lozada in the show notes of this decision, as it is so relevant and important, as you will see in just a second. After the BIA denied, Ms. Garcia-Gonzalez got a third attorney, who filed a bar complaint against both prior attorneys, and moved the BIA to reopen. Even with the bar complaints filed, the BIA denied the motion to reopen, 2 years later. It reasoned that even if Ms. Garcia-Gonzalez had been able to bring her claims because she had gotten her fingerprints taken, she wouldn't have likely won. The BIA didn't think that, quote, Kevin's nuclear family, end quote, was socially distinct in Honduras. I'll tell you something, though. It's very much so in Cooper City, Florida. Anyway, the BIA held that it wasn't a cognizable particular social group, meaning that Ms. Garcia-Gonzalez couldn't have won anyway, even if counsel hadn't committed the unforgivable sin of forgetting to get a fingerprint appointment. To the Fifth Circuit it went. That is, was the BIA right to deny the motion to reopen? Now, in some circuits, and indeed recently, it has been reiterated that nuclear families are the quintessential particular social group. And really, not much more analysis has been provided in those decisions lately. Nuclear families have easily qualified of late. The Fifth Circuit is special, though. It, quote, typically denies petitions in cases involving gang activity directed at a family on the basis that petitioners did not prove nexus, end quote. This decision here is solely about whether the family group is cognizable, not about why the gang targeted Ms. Garcia-Gonzalez. And going all the way back to matter of Acosta from 1985, quote, the BIA has consistently recognized that families can be particular social groups in at least some circumstances, end quote. The Fifth Circuit then goes on to explain the fight over matter of LEA 1 and matter of LEA 2, and then how Attorney General Garland vacated matter of LEA 2 and promised regulations on the issue, regulations that were promised almost 2 years ago, apparently. Quote, we do not have even a draft of the proposed rule, end quote. Faced with all of this back and forth on whether a family group is cognizable under asylum law, Oil kinda looked silly and apparently requested that the Fifth Circuit rule against Ms. Garcia-Gonzalez on narrow grounds and without discussing whether her particular social group was cognizable. Quote, the United States urges us to rule narrowly and deny Ms. Garcia-Gonzalez's petition on the ground that she did not present any evidence at all regarding social distinction of her proposed group. Thus, the Department of Justice issued guidance, vacated that guidance, was instructed to provide new guidance, failed to provide said guidance, and now asks us to refrain from providing any meaningful guidance ourselves, end quote. The Fifth Circuit begrudgingly obliged. Seems like Ms. Garcia-Gonzalez, through third counsel who had filed those ineffective assistance of counsel complaints against the other attorneys, didn't delineate precisely why the family-based particular social group was socially distinct. Something that might not even be a failing in other circuits, to be honest with you, but it was here, and especially with this procedural posture. Got a brief social distinction. Quote, because she did not, she failed to make out a prima facie case of eligibility for withholding of removal or asylum. The consequence is that she failed to demonstrate any prejudice caused by allegedly ineffective counsel, end quote. Motion to reopen denial affirmed, bar complaints for nothing. As to CAT, which requires no nexus, the Fifth Circuit didn't see much evidence that police would acquiesce to the torture that Ms. Garcia-Gonzalez feared. And I mean, after all, she never got a chance to bring her case below, right? As to the BIA's refusal to reopen proceedings using its sua sponte authority, that is, perhaps realizing the absolute mess and inequity that strict application of Lozada is causing the immigration bar, and in this case, well, the Fifth Circuit affirmed its prior precedent, saying that because sua sponte reopening is so discretionary, it, the court, lacks a standard and therefore jurisdiction to review the BIA's refusal to exercise that authority. It doesn't matter that Ms. Garcia-Gonzalez was making constitutional due process arguments, they were still coming under the guise of a sua sponte reopening request, and the Fifth said, we can't review it. Which means Ms. Garcia-Gonzalez and her son lost their case. And that is Garcia-Gonzalez v. Garland. Heading to the First Circuit. First, Yoc Esteban v. Garland, published by the First on August 7th, 2023. This case is about motions to reopen. Mr. Yoc Esteban entered the United States in 2014 at 19 years old. He was served with a notice to appear shortly thereafter and filed for asylum in immigration court. Apparently, he didn't clearly delineate the particular social group that his claims were based on. He testified essentially that some drug dealers were threatening him. An immigration judge denied. The BIA affirmed and refused to consider the particular social groups asserted for the first time on appeal. And it refused to remand for presentation of new evidence. New counsel filed another motion to reopen later based, you guessed it, on ineffective assistance of counsel. Mr. Yoc Esteban argued that, quote, his prior counsel was ineffective because she failed to comply with the IJ's order to delineate a particular social group, which was fatal to Mr. Yoc Esteban's claim. Because she failed to amend Mr. Yoc Esteban's pleadings to include an application for withholding of removal and CAT protection. And because she failed to sufficiently represent Mr. Yoc Esteban on direct examination, end quote. The BIA denied the motion for reasons that the BIA denied the motion similarly in that Fifth Circuit case that we just discussed. No prejudice. The BIA just didn't see an asylum claim here. Also, some other stuff. The First Circuit affirmed that. Bar complaints aside, to succeed on an ineffective assistance of counsel motion to reopen, or really an ineffective assistance of claim under any framework, the non-citizen must show that, quote, 1. Immigration counsel's performance was deficient, and 2. Immigration counsel's performance caused prejudice to the client, end quote. Prejudice is so often the issue in these cases, and to me, the standard can be a bit circuit-specific. In the first, prejudice required that Mr. Yoc Esteban, quote, had to prove a reasonable probability that but for counsel's error, the outcome of the proceedings would have been different, end quote. And yes, that seems very similar to the prima facie standard we just discussed in the Ninth Circuit decision. Not met here, though. First, the First Circuit noted that even this, the ineffective assistance of counsel motion to reopen, failed to identify what particular social groups initial competent counsel should have raised before the IJ. Looks like Mr. Yoc Esteban made them to the First Circuit, but not to the BIA in the actual motion. But you kinda gotta make those arguments to the BIA if you want them to grant your motion. Nor did BIA counsel at least explain Mr. Yoc Esteban's eligibility for withholding of removal or cat protection. Now true, and really as new counsel argued to the First Circuit, quote, there is no legal or strategical reason to only apply for asylum, which is why the I-589 application encompasses all three forms of relief in one application, end quote. But still, gotta explain eligibility to succeed on these motions to reopen. And particularly with an ineffective assistance of counsel motion being so serious and difficult to win on, substantive explanation and argument was required by the First Circuit. Nor did Mr. Yoc Esteban really outline what new testimony he would have provided but for the allegedly ineffective assistance. So the BIA saw no prejudice in whatever assistance Mr. Yoc Esteban received below, and the First Circuit affirmed that. And that is Yoc Esteban v. Garland. Sticking with the First Circuit but giving a bit of a breather on motions to reopen, we turn to Vila-Castro v. Garland, published by the First on August 8th, 2023. This case is about government action and asylum-type claims. The petitioners are a family from Peru who entered the United States in 2014 and 2015. They applied for asylum and related relief in removal proceedings. Their claims were based on their previous involvement with the American Popular Revolutionary Alliance, or APRA, political party in Peru. Indeed, some of their family were elected mayors from that political party. As a result, so the petitioners testified, they were attacked on a motorcycle by members who they believed were from the opposition political party. An intentional car accident, they testified. Later, the family received an anonymous threatening letter at their home that specifically referenced their involvement in the APRA party. Quote, police responded that they could not investigate the letter because it was anonymous, end quote. Unsatisfied with that and apparently having some people in high places, the petitioners went all the way up to Peru's interior minister, and the minister provided a letter to them ordering police to investigate that anonymous letter. But the petitioners never brought the letter to police because they didn't think police would help even if they got the interior minister's letter. Finally, after an election day in 2014, APRA members, including one of the petitioners, were attacked by opposition party members. They were, quote, all aboard a large boat, and a group of supporters of opposing parties threw rocks and sticks at them to prevent them from disembarking, end quote. Deeming the story credible, the IJ and the BIA denied. The First Circuit affirmed that denial, primarily on the government actor prong required for asylum withholding and cat protection. To the First Circuit, like the BIA, petitioners couldn't show that the Peruvian government was unable or unwilling to protect them as asylum and withholding requires, or that the government would likely acquiesce as the Convention Against Torture requires. Comes back a lot to that interior minister, really, at a minimum. The minister gave the letter ordering police to investigate that threat. The BIA wasn't crazy to conclude that that showed that the government was willing, and they might have been able to if given the chance, reasoned the First Circuit. Quote, although corruption is a pervasive problem in Peru, the Peruvian government does take some action to investigate and prosecute corruption, and the evidence that the petitioners put forward does not compel a contrary conclusion, end quote. Legalese for the BIA was not crazy. Now, it is true that the IJ and the BIA err if they fail to distinguish between unable and unwilling. Those are two separate analyses, and a non-citizen need only establish one to meet the government actor prong for asylum or withholding of removal. That is, that the government is either unable or unwilling to protect. Remember that. But that issue wasn't at play here. Cat was denied for similar reasons. The First Circuit saw an insufficient government connection, even assuming a sufficient future torture showing. And that is Vila-Castro v. Garland. Returning to the Ninth Circuit with Reyes-Corado v. Garland, published by the Ninth Circuit on August 11th, 2023. Did I mention that it's motion to reopen week? Similar panel to the one that just made super clear in the Ninth Circuit what the motion to reopen standard is. So let's see what they have to say about changed country condition motions to reopen, shall we? Mr. Reyes-Corado is from Guatemala. In 2005, he sought asylum and related relief in immigration court, quote, based on strife within his extended family during and after the Guatemalan Civil War, end quote. See, his father and uncle had fought on opposite sides of that terrible war in the 1980s and 1990s. His father was affiliated with a military group, while his uncle with the guerrillas. His uncle killed his own nephew, Mr. Reyes-Corado's cousin, in 1990. Then the uncle disappeared, and the uncle's son was killed. Mr. Reyes-Corado's father and the military-affiliated auxiliary group that he was with were suspected. Quote, the Guatemalan Civil War formally ended in 1996. In 2003, a few years after Mr. Reyes-Corado's arrival in the United States, his uncle's sons shot and killed Mr. Reyes-Corado's father in his home, end quote. And that was the gist for the basis for the asylum claim in immigration court many years ago. A claim that the immigration judge granted, and which the BIA reversed. Pretty surprising fact-intensive reversal, it seems, based on this decision. Mr. Reyes-Corado moved for reconsideration, and the BIA doubled down. The Ninth Circuit ultimately affirmed the BIA's denial by unpublished decision. But remaining in the United States, Mr. Reyes-Corado moved to reopen his case in 2017, arguing that things had changed materially in Guatemala, such that he could now establish prima facie eligibility for asylum. A standard the Ninth Circuit just clarified, remember? Prima facie eligibility for relief? Namely now that the uncle's sons, his cousins, quote, threats against Mr. Reyes-Corado and his family had persisted and intensified, materially affecting Mr. Reyes-Corado's eligibility for relief, end quote. The BIA denied. This time, the Ninth Circuit remanded. Because to begin, while motions to reopen are of course disfavored, they also serve as a, quote, important safety valve in the asylum process, end quote, where new evidence becomes available, of course. And you'll be seeing that on the social medias, folks. And that safety valve is particularly important here, where the BIA messes up. First, the BIA dinged Mr. Reyes-Corado for failing to file a new asylum application with his changed country condition motion to reopen. And yes, usually when you file a motion to reopen based on eligibility for new relief, you need to, at a bare minimum, file that relief application. But that doesn't make any sense when you're talking about a motion to reopen where an asylum application Form I-589 has been previously filed. And what the non-citizen seeks to do is get consideration of new material evidence on that same claim. That's Aliyev v. Barr out of the Ninth Circuit, BIA, Episode 18. Duh. Some other circuits too. And it's a rule that just makes sense. Now true, in Aliyev, the petitioner included a copy of the old I-589 with the motion to reopen. Mr. Reyes-Corado did not. But why should that matter, reasoned the Ninth Circuit here. Specifically, quote, consistent with the plain text of 8 CFR section 1003.2 C1 and various persuasive authorities, we hold that the first type of motion to reopen, one, like Mr. Reyes-Corado's, that adds new circumstances to a previously considered application, need not be accompanied by an application for relief, end quote. Regulatory interpretation, and a, quote, needless formality, end quote, to hold otherwise. After all, the record in such cases has and always will have that old I-589 that's forming the basis for the claim. Aliyev extended in the Ninth Circuit in a way favorable for non-citizen change country condition motions to reopen. On to the meat, whether Mr. Reyes-Corado established materially changed circumstances that now warrant reopening. Not so easy actually, because in addition to all the regular asylum elements that must be met there, the BIA had previously deemed Mr. Reyes-Corado's application time-barred, as that first application was filed over a year after Mr. Reyes-Corado entered the United States. So how could new evidence 17 years later make that application timely? Well, quote, there is no time limit for a motion based on changed circumstances arising in the country of nationality or in the country to which deportation has been ordered if such evidence is material and was not available and could not have been discovered or presented at the previous hearing, end quote. Duh. I'm just kidding, BIA. It's complicated stuff. Without getting too deep into it, here the Ninth Circuit saw the motion to reopen evidence, which included sworn affidavits, as showing, quote, an escalating campaign of threats, harassment, and physical violence against Mr. Reyes-Corado's family in Guatemala, including children and Mr. Reyes-Corado's elderly mother, end quote. The BIA had seen this evidence as just more of the same, rather than a material change from the asylum claim way back when, but to the Ninth Circuit, this evidence rebutted the BIA's denial from 2006, and showed that Mr. Reyes-Corado's extended family in Guatemala sought retribution upon Mr. Reyes-Corado for what happened to the uncle and some cousins and that whole dispute. And there was a lot here. Houses getting shot up, the murder of family pigs and chickens, lots of graphic death threats to the family, stuff against the elderly mother. It goes on and on. To the court, this met the materiality standard. The new evidence showed that, quote, circumstances have changed sufficiently that a petitioner who previously did not have a legitimate claim for asylum, end quote, now does. The standard is not a, quote, dramatic change, end quote, particularly where, as here, circumstances were, quote, already severe, end quote. The fact that it all continued for 14 years after the BIA's decision, and even got worse, shows how serious everything is in Guatemala for Mr. Reyes-Corado. As does the fact that now, in addition to the death threats, we have physical acts of violence in Guatemala against the family, elderly mother, and the family's farm animals. Nor does it matter to the Ninth Circuit that this was an intra-family change. As the court has often explained, quote, change country conditions that occur in the country of nationality and are entirely outside the petitioner's control may constitute changed country circumstances even if they are personal, painful, or life-altering, end quote. In short, it doesn't matter that it's a family dispute or that it's all really the same thing that was denied before. What matters for changed country condition motions to reopen is the, quote, new circumstances take that fear across the threshold for a well-founded fear of future persecution or otherwise materially affect the petitioner's entitlement to relief, end quote. Remanded. Which means congratulations to my literal neighbors, David A. Schlesinger and Ginger Jacobs, along with Kai Medeiros and Paulina Reyes of Jacobs and Schlesinger LLP. Really pushing the ball forward on changed country condition motions to reopen in the Ninth Circuit, guys. And by the way, it's hard to think of a situation where a motion to reopen will be filed without including a sworn affidavit from the non-citizen and perhaps others. And as the Ninth Circuit explained here, kind of similar to defending a summary judgment motion in federal court, quote, the facts alleged in the declaration must be accepted as true for purposes of ruling on the motion to reopen, end quote. That's a rule I can live with and, of course, is applicable to a broad range of motions to reopen. I'm thinking, for example, no notice in absentia removal order motions to reopen. Assuming that you get that one case where the NTA isn't deficient, of course. And that is Reyes-Corado v. Garland. This podcast is sponsored by Journey Business Plans. Journey is the leading business immigration plan writing company in the United States. 10 years. And they know immigration. Heck, they started as an E2 company themselves. Journey prides itself on its responsiveness and overall customer service, preparing business plans for E2, EB2 NIW, L1, EB5, and much more. If you don't yet know about Journey, and don't want to listen to just me, ask your colleagues. Or even better, try them out. Visit www.journey.com and use promo code REVJOURNEY30 for a 30% discount on your first business plan. That's REVJOORNEY 30. Or click on the link in the show notes. Next is Wachichovic v. Garland, published by the 7th Circuit on August 8th, 2023. What a case this is. And admittedly, I'm having a bit of trouble with this name, so I'm going to call the petitioner the petitioner. The petitioner is from Poland. He came to the United States in the late 1980s, married a U.S. citizen in 1999, has 2 U.S. citizen children, and became a lawful permanent resident in 2004. But in the 2000s, he began stealing money as a subcontractor by double billing for his work, netting about $100,000. He received a few convictions that are CIMTs, all arising out of that scheme, it seems. And if you know your crimmigration, you know that if a CIMT arises out of the same scheme of criminal conduct, it shouldn't make an LPR removable. But when the petitioner went to Poland in 2019 for his sister's funeral, he was in big trouble, because only one CIMT is required to bar an LPR from re-entering, because it'll make that LPR inadmissible under INA Section 212 and permit ICE to treat the returning LPR as what we call an arriving alien. That's the law even if there's only one CIMT, or even if there are multiple from the same scheme of criminal conduct, and even if that CIMT or CIMTs wouldn't make the LPR removable had he just remained in the United States. That is what happened here, as the 7th Circuit later explains. The petitioner was not removable under INA Section 237, but he was inadmissible provided that he left the U.S. and sought re-entry, which he did because his sister passed away. Detained, it appears, maybe at the height of the Trump administration on his way back into America, ICE treated the petitioner as an arriving alien who was inadmissible. The petitioner was in trouble. He applied for an INA Section 212H waiver, which an IJ denied as a matter of discretion after weighing all the positive and negative factors of the case. The BIA affirmed, as did the 7th Circuit, and removal was set for November 27, 2020. But a week before that date, Illinois Governor J.B. Pritzker pardoned all the criminal conduct. Incredible. The petitioner has no criminal convictions from the state of Illinois, or anywhere else, it seems. So the petitioner moved for an emergency stay of his removal with the BIA, which the BIA granted. He also moved to reopen his proceedings. Quote, "The BIA granted a stay of removal, but ICE, in clear violation of the stay and with no accompanying explanation, removed the petitioner to Poland. He has remained there since." End quote. Can you imagine that? Can you imagine that? Then the BIA denied the motion to reopen. Essentially, the BIA explained, while a governor's pardon makes a state conviction go away, it doesn't necessarily die for immigration purposes. Few things ever do. The pardon statute under immigration law really only applies to certain removability provisions contained at INA Section 237. But that pardon statute under the INA doesn't, by its terms, apply to the inadmissibility provisions at Section 212. Which makes some sense, at least. Some of those Section 212 inadmissibility provisions don't even require a conviction. The petitioner really should never have left the U.S. But he was in a bind. So yes, we have another motion to reopen review this week. And the fact that the 7th Circuit reviewed the issue in any way is significant, given that this whole matter was traveling under the guise of a request that the BIA exercise its sua sponte authority to reopen proceedings. As we so often and just discussed, circuits generally don't have jurisdiction to review such things. Too discretionary. But review the 7th Circuit did. So, under the INA's pardon statute, INA Section 237A2A VI, The CIMT and some limited other grounds of removability at Section 237, quote, shall not apply in the case of a non-citizen with respect to a criminal conviction if the non-citizen subsequent to the criminal conviction has been granted a full and unconditional pardon by the President of the United States or by the governor of any of the several states, end quote. Presumably all states. But Congress did not add a similar pardon provision at Section 212 of the INA, the portion of immigration law that governs inadmissibility. That is, people trying to come into the United States or to adjust to LPR status if already in the U.S. There are a variety of ways where the inadmissibility provisions of Section 212 will apply to people, even sometimes LPRs like the petitioner here. The petitioner said whatever. He no longer has any convictions. He's admissible. The Seventh Circuit disagreed. Quote, a pardon for a crime involving moral turpitude cannot make an otherwise inadmissible non-citizen admissible, end quote. Congress wrote the statutes in the way it did and made the pardon authority apply only to Section 237 removability. This is the case, the Seventh Circuit explained, even though the Department of State in the FAM states that, quote, in clear terms, a non-citizen, and now quoting the FAM, shall not be considered ineligible under the CIMT inadmissibility provision by reason of a crime involving moral turpitude for which a full and unconditional pardon has been granted by the governor of a state of the United States, end quote. Statute trumps regulations, FAM, and anything else, explained the Seventh Circuit. Quote, where agency regulations conflict with statutory text wins out every time, end quote. But what about the Constitution? I'll get back to that in a sec. And even if a pardon takes away the conviction, the inadmissibility provision, as we discussed, applies to non-citizens who have merely admitted to the essential elements of a CIMT. The petitioner here still admitted to his crimes all those years ago, which are CIMTs. That's why inadmissibility is so dangerous. The Seventh Circuit also addressed the petitioner's constitutional-based arguments, even though he never made them before the BIA, which of course the BIA lacks authority to hear anyway. The Seventh Circuit agreed that non-citizens are treated differently than our citizens when it comes to pardons. But the Seventh held that that's not an equal protection violation. There are many legitimate reasons that the Seventh Circuit saw for Congress to treat non-citizens and citizens differently when it comes to pardons. What about ICE's complete disregard of the BIA's stay? Free pass. The Seventh Circuit does, however, voice its, quote, frustration and disappointment, end quote, with ICE and sympathizes with the petitioner and his U.S. citizen family. The petitioner therefore lost his case. Before we depart, this case was all about governor's pardons. Most circuit cases and the BIA's seminal pardon case are too. But that INA pardon statute actually also covers presidential pardons, as I mentioned. And those are rarely, if ever, adjudicated because they are rarely given out, and even rarer are they given out to non-citizens. To me, though, there are compelling constitutional arguments for why a presidential pardon should apply and wipe away all immigration consequences, including inadmissibility and not just the removability consequences at Section 237. And an Office of Legal Counsel memo from the Clinton years agrees. Shoot me a line if you ever get the case. The arguments are fun. And that is Wakichovic v. Garland. Almost done, but not quite yet. Next is USA v. Chabas, published by the Eighth Circuit on August 11th, 2023. This case is about material misrepresentation, in the denaturalization context. When it rains, it pours, as you'll see with the 11th Circuit case that I'm about to do, and recorded 3 days before this one. As with so many denaturalization cases, it's complicated. Ms. Chabas is from Kenya. In 2005, she had a different last name, and won the diversity lottery. That would have qualified her and her husband, and I believe her children, had she had any, to enter the United States as immigrants. She did. In her diversity visa application, she had listed that she had a certain husband, a man named Gideon. When she sat for her visa interview, though, she lied and said that Gideon had died. She probably did that because by that time, according to this decision, Gideon had been to the United States and overstayed a tourist visa in the US and had just been denied another tourist visa from Kenya. He was inadmissible to the United States due to that overstay, even though his wife, Miss Chabas, had just won the visa lottery. Recall what almost happened, but didn't happen, to Ayla President Farshad Auji with his diversity visa lottery experience. And check out that special episode podcast interview if you haven't yet, people. Anyway, it seems like Miss Chabas lied and came to the United States herself without her husband, saying that her husband Gideon had died. And in 2008, while in the United States, Gideon used a false alias with the name Chabas to obtain a G2 visa, a non-immigrant visa for government representatives that, to be honest, I've never heard of. Quote, falsely stating that he would represent Kenya at the 63rd session of the United Nations General Assembly, end quote. And look, I don't condone lying to immigration authorities, but man, do I admire the chutzpah here. If you're gonna do it, might as well go all in. And it worked. He got his G2 non-immigrant visa. He did not represent Kenya at the UN, and he overstayed. Meanwhile, Ms. Chabas filed an I-130 petition for Mr. Chabas. Again, fake alias. This is still her husband Gideon. Falsely stating that Mr. Chabas was someone different from her first husband who had died, but again, he's not. He's the same dude, alive and well, and not representing Kenya at the United Nations. She even submitted a fake death certificate with that I-130 petition that she swore to. Not looking great, and I don't want to make light of the seriousness of all this, but I'd be lying if I said I was not enjoying this case. USCIS approved the I-130 petition. And then Ms. Chabas naturalized, which allowed Gideon to become a lawful permanent resident because now that I-130 approval was an immediate relative petition, meaning the fact that he had overstayed his G2 visa was not a per se bar to his adjustment. At least not under INA Section 245C, and due to the overstay only. The fraud part about representing Kenya at the UN, if discovered, totally would bar him from adjusting. Gideon adjusted to LPR status in 2011. And then DOJ eventually figured it all out, possibly through its Trump-era denaturalization task force, and initiated denaturalization proceedings against Ms. Chabas by filing a complaint in federal court. Because see, in addition to swearing that she had never provided false or misleading information to USCIS while applying for any immigration benefit, Ms. Chabas also listed 2 marriages in her N-400 naturalization application and the death of her first husband, which again was all false. At her eventual denaturalization trial, the district court judge found it persuasive that there were red check marks on the N-400, indicating that those N-400 questions about her family, her husband, whether she had ever given misleading information, all that stuff, had actually been asked at the interview. Quote, it is USCIS practice to use red check marks or slashes to indicate answers that the applicant orally confirmed at the interview, and that information in red handwriting means the applicant provided it at the interview. End quote. Proceedings were also brought against Gideon, and Gideon gave up quick and pled guilty to attempted naturalization fraud before his criminal trial. Not looking great for Ms. Chabas. And actually, I think I misspoke. This is a criminal trial. Ms. Chabas received a 3-year supervised release, which included a motion by the government to revoke her citizenship after her trial. This isn't actually a denaturalization proceeding, it's a criminal proceeding for related conduct that resulted in her denaturalization as well. She appealed her criminal conviction and her denaturalization to the 8th Circuit, which affirmed the district court. The criminal statute at issue here, 18 U.S.C. Section 1425A, quote, requires the government to prove that the defendant knowingly procured, contrary to law, the naturalization of any person, end quote. And under another criminal statute, it is, quote, contrary to law, if a person knowingly makes any false statement under oath in any matter relating to naturalization, citizenship, or registry of aliens, end quote. To be material for naturalization purposes, the government must show that the, quote, defendant lied about facts that would have mattered to an immigration official, end quote. That is, that the statement, quote, somehow contributed to the obtaining of citizenship, end quote. That's the Supreme Court's Maslin-Jack decision from 2017, and as so stated, it's a materiality standard that I can work with. Ms. Chabas argued that her lies weren't material to her naturalization. After all that fraud stuff that she did was in regards to her husband, not actually her, and it never regarded her own immigration petitions, visa eligibility, or naturalization application. The thing is, though, that in Maslin Jack, the Supreme Court employed a standard that I, as an advocate for non-citizens, hate, and that USCIS loves so very much, whereby a false statement is material based on a, quote, investigation-based theory, which requires proof that 1. The misrepresented fact was sufficiently relevant to a naturalization criterion that it would have prompted reasonable officials to undertake further investigation, and 2. That the investigation would predictably have disclosed some legal disqualification, end quote. To me, it still requires playing out the game to the end of the road and showing that the investigation would have led to inadmissibility or a naturalization bar or something like that. It's a heavily litigated area of law. But at a minimum then, said the Eighth Circuit, if USCIS had known all the actual correct information, they would have predictably concluded that Ms. Chabas lacked the good moral character required to naturalize. Indeed, one of the per se bars to good moral character at INA section 101F6 is the, quote, giving false testimony for the purpose of obtaining an immigration benefit, end quote. Undiscussed and seemingly unargued here, but to the Eighth Circuit it didn't matter that all those false statements regarded really Gideon's admissibility, and not Ms. Chabas's immigration benefits. The Eighth Circuit therefore affirmed the conviction. And all this stuff is important not just for criminal prosecutions, but also to denaturalization cases and immigration law generally, because it's regarding what INA section 101F6 requires, and what is a material false statement. For example, Ms. Chabas argued that actually, Section 101F6 is limited to false statements made verbally and under oath. So I guess not statements made simply in the N400 or I-485 if not asked verbally at the interview? The Eighth Circuit didn't say that that theory was incorrect. The Eighth Circuit kind of punted on that. Interesting. And that argument is based on the Supreme Court's discussion of what is testimony in its much older Cungus decision. The Eighth Circuit punted, though, because it was satisfied that those red check marks showed that Ms. Chabas was indeed asked the relevant questions orally at her naturalization interview. So again, conviction and denaturalization affirmed. What a case. And that is USA v. Chabas. Our final case is USA v. Lopez, published by the 11th Circuit on August 7th, 2023. This case is about the categorical approach, conspiracy offenses, CIMTs, and denaturalization. That makes it an absolute maze. Let's go. Ms. Lopez is a naturalized U.S. citizen from Venezuela. She applied to naturalize 20 years ago, at which point she swore, as you always do, that she had never, quote, committed a crime or offense for which she was not arrested, end quote. I'm going to stop right here, and it's a long one, so I apologize, but I'm going to stop right here and just query to every listener whether they could truly, in their heart of hearts, answer no to that ridiculous question. But non-citizens always do. Ms. Lopez attested to the same when she took her oath and became a citizen in 2007. But in 2012, she was charged with healthcare fraud and conspiracy crimes. She eventually pled guilty to money laundering in violation of 18 U.S.C. section 1956H. And when she did, she admitted that the scheme had run from August 2004 to July 2008, within the time period that she had affirmed before she became a citizen that she had not committed a crime, and during which time she needed to show that she had good moral character. Seems like she was helping her husband submit millions of dollars worth of false Medicare claims. A very Southern District of Florida offense. In her plea agreement, Ms. Lopez acknowledged that her plea would result in her denaturalization. But that doesn't happen unless DOJ gets around to doing it, which they did in 2021 by filing a federal complaint in the Southern District of Florida. DOJ's complaint alleged that Ms. Lopez, quote, had illegally procured her naturalization on the ground that she had failed to meet the requirement of good moral character, end quote. Continuing on, DOJ also alleged that Ms. Lopez, quote, had committed a crime involving moral turpitude and had willfully misrepresented or concealed the fact that she had committed a crime during the naturalization process, end quote. Ms. Lopez moved to dismiss the complaint. The district judge denied that motion and then granted the Department of Justice's motion for judgment on the pleadings, ruling against Ms. Lopez. The district court judge, quote, concluded that the conspiracy crime to which Ms. Lopez pleaded guilty overlapped with the statutory good moral character period and that her crime of conviction involved moral turpitude, end quote. The 11th Circuit did not agree on the CIMT issue. In cases like this, at least, federal law requires, quote, that an applicant for naturalization be a person of good moral character for 5 years before filing her application up to the time she is granted citizenship, end quote. The good moral character requirements are outlined at INA Section 101F. Commission of a CIMT during that good moral character period, here 5 years, is specifically listed by the statute as preclusive of a good moral character finding, which is why the 11th Circuit analyzed whether this conviction is a CIMT here. No matter the context, the CIMT analysis requires application of the categorical approach. The focus of that approach is on the criminal statute of conviction. In the CIMT context, it's whether it necessarily criminalizes base, vile, or depraved conduct, as the CIMT definition describes. Quote, if the crime could be committed in a manner that does not involve moral turpitude, then the statute is overbroad. That is to say, it does not categorically involve moral turpitude, end quote. What about conspiracies, though? That's what we have here, remember? The court believed it a bit unsettled in the 11th Circuit, so it settled it. Quote, when a defendant has been convicted of conspiring to commit a crime, the categorical approach requires the court to determine whether the statute defining the underlying crime is divisible, if it would otherwise be overbroad, end quote. That is, explained the 11th, the focus is on the underlying crime at issue. So here, whether completed money laundering would be a CIMT, even though this is only a conspiracy to commit money laundering. The focus is on the object of the conspiracy. The BIA says the same, as do many circuits. That conviction here is 18 U.S.C. Section 1956H, the Special Money Laundering Conspiracy Statute. That statute is divisible, explained the 11th Circuit. To be guilty of it, the prosecution must show that an individual conspired to violate a specific subsection of either 18 U.S.C. Section 1956 or Section 1957. Here the allegation was a conspiracy to launder money in violation of Sections 1956A1BI and Section 1957. There are a lot of subsections for 1957, so that's pretty broad. The relevant Section 1957 provision is broad, and it criminalizes, quote, knowingly engaging in a monetary transaction in criminally deprived property of a value greater than $10,000 and derived from specified unlawful activity, end quote. Section 1956A1 similarly criminalizes monetary transactions done with illegal criminal proceeds. It criminalizes many things. We're about to get kind of deep into the money laundering statutes, which are also applicable to the inadmissibility money laundering provision, but are rarely discussed. It's pretty complicated. We can actually stay a bit above the weeds because this decision really is about divisibility. Some of you may be wondering, if you were listening at the beginning, wait, wasn't the alleged underlying allegation Section 1956A1BI? Why are we talking about Section 1956A1 or Section 1956A1B when the prosecution specifically alleged a conspiracy to violate Section 1956A1BI and, of course, 1957? Well, despite that very clear charge, the 11th Circuit said that Section 1956A1B is not divisible into two separate crimes of subsection I and II. Subsections I and II are means of committing the offense rather than elements. Stepping back, that is a big holding for crimmigration folks. It's a judicial admission, essentially, that prosecutors, Indeed, federal prosecutors sometimes overcharge with too much specificity, and that courts should not simply be relying on the charging documents and the charging decisions of the prosecutor to determine a statute's divisibility. The reason? That is, the reason that subsection 1b is not divisible into separate crimes? Well, without getting too deep in the very long and confusing decision, the difference between the two subsections at subsection B, quote, lies only in what facts the defendant knew about the nature and purpose of the transaction and funds at issue, end quote. Looks like the 11th Circuit is saying that proof of the same facts will support a subsection I or a subsection II conviction. And that makes those two subsections means rather than elements of the money laundering statute. Okay, so the 11th Circuit has limited the scope of what it can look at for the CIMT analysis. It's looking at Section 1957 and at Section 1956 A1B without looking at the specific subsection A1BI. That means that Mrs. Lopez's conviction is only a CIMT if in all instances a Section 1957 violation is a CIMT, or if in all instances a Section 1956 A1B conviction is a CIMT. What is a CIMT? Well, we discussed it a bit above, but as relevant for crimes like this that don't require physical harm, it's usually crimes that require fraud. But as the 11th Circuit recently explained in its Zarate decision, episode 96, even for fraud-type crimes, quote, the crime must still involve conduct that is inherently base, vile, or depraved, end quote. That's your North Star, CIMT travelers. Base, vile, or depraved. With that standard in mind, the 11th quickly dispensed with Section 1957. Quote, engaging in a transaction with criminally deprived property is not inherently fraudulent and does not necessarily require deceit, end quote. Nor is it inherently base, vile, or depraved. Not a CIMT. And now for the knockout blow. Quote, structuring a transaction to avoid a reporting requirement as defined at 18 U.S.C. Section 1956 A1B II is also not a crime categorically involving moral turpitude, end quote. It might involve deceit. Arguable, said the 11th Circuit. But even if it does, it's not inherently base, vile, or depraved. The structuring and reporting of financial transactions have, quote, no inherent moral significance, end quote. Many circuits seem to agree, albeit in some other contexts. Going back to criminal law, it seems that maybe the 11th Circuit is saying that the statute is malum prohibitum rather than malum in se, as it simply, quote, deprives the government of information, end quote. I bet some tax money too, but that's not really discussed. Therefore, said the 11th Circuit, even though Miss Lopez was actually convicted of a conspiracy to commit the BI offense, the fact that the BII offense is not a CIMT makes the entire conviction not a CIMT, no matter what Miss Lopez actually did. That means that the district court judge was wrong to grant summary judgment on that basis, and so it was all sent back for further analysis. So, although the 11th Circuit doesn't make its attorneys known in its day of decision, the platform formerly known as Twitter has allowed me to deduce that congratulations are due to Matthew Hoppeck for appellant. And thanks for talking to me about the case, Matt. Awesome win for your client. It's not even close to over yet, because not to think like the government, but I must admit I'm a bit confused. As I understand the law, regardless of whether the crime is a CIMT, Ms. Lopez should probably be denaturalized. The denaturalization statute permits denaturalization if citizenship is illegally obtained. That false claim of having not committed criminal conduct when she applied to naturalize and when she took her oath might itself suffice. And perhaps more importantly, the good moral character statute has a catch-all provision that permits USCIS to rely on any bad conduct during the statutory period to deny naturalization, even if it's not specifically defined and even if it's not a CIMT. It's for this reason, for example, that immigration attorneys almost always advise that non-citizens with DUIs and certainly multiple DUIs during the pre-naturalization statutory period wait to apply. USCIS is likely to deem such convictions indicative of bad moral character, even though simple DUI is neither an inadmissible or removable offense. Maybe there was a unique procedural posture on the summary judgment that got this very narrow CIMT analysis before the 11th Circuit. But regardless of how it got there, the 11th Circuit's analysis is quite important. And for Ms. Lopez, even if she is ultimately denaturalized, the fact that her conviction isn't a CIMT may yet prevent her removability. Then again, this statute is a per se aggravated felony at INA Section 101A43D. But then again, even if it is, I don't think it can make Ms. Lopez removable as an aggravated felony, even if she gets denaturalized, because her actual conviction occurred after she naturalized. So she wasn't an alien at the time of conviction, which means that aggravated felony statute doesn't apply. Thank you very much, Hilton v. U.S. Attorney General, episode 49. And whatever, 11th Circuit practitioners, rejoice in this non-citizen-friendly crimmigration decision. And that is USA v. Lopez. So there you have it. You're all caught up with the past week's published immigration cases. I'm Kevin A. Gregg, a partner with the law firm Kurzban, Tetzelli & Pratt, and this has been another episode of Immigration Review. Thank you for listening, and I hope you enjoyed it. If you did, please share it with a friend and rate and review us. Each review helps new listeners find the show. And of course, subscribe to Immigration Review wherever you get your podcasts. If you like what we do and want to become a patron of the show, please check out our Patreon page at www.patreon.com/Immigration Review or click on the link in the show notes. And if you're interested in an official Immigration Review CLE certificate, email me at kgreg@kktplaw.com with your full name and the episode numbers for the 10 shows you've listened to. Also, feel free to email me with questions, comments, or anything at all, and follow the show on Instagram and Facebook at Immigration Review, or send us a tweet at ImReview, that's IMM Review. I'll be back next Monday for a brand new discussion. Until then, I'm Kevin A. Gregg, bringing you the Immigration Review.